the Supreme Court in Israel has asserted the power and has exercised the power to govern and to decide what's reasonable. And that is the assault on democracy. And what the governing coalition is now attempting to do is to reverse that.
Hello, I'm Jonathan Tobin, editor-in-chief of the Jewish News Syndicate, jns.org, and you're listening to Top Story, a weekly podcast where I analyze the most important stories happening in Jewish news around the world. Each week, I will break down politics, foreign policy, and culture to provide insights into what is going on behind the headlines. Hello, and welcome to Top Story. Thank you for joining us. Today, we have an important conversation for you with legal expert Jerome Marcus about the question of judicial reform in Israel and how its Supreme Court operates. But before we start, I want to encourage everyone to like this video and podcast, subscribe to JNS, and click on the bell for notifications. Also, we would love to hear from you. Please write to us at editor@jns.org and let us know where you listen or watch the show and what you think of it. I also want to remind you that you don't have to wait a full week for more Top Story analysis. There is a daily Top Story podcast where I share more news and analysis with you about the most important issues we're facing today. You can find the daily show under Top Story with Jonathan Tobin on the JNS channel on Apple, Spotify, Google Play, or wherever you get your podcasts. And now to today's program. If you read or watch any mainstream corporate media outlet coverage of Israel, or even the reporting and commentary in most Jewish publications, you have been left in little doubt that democracy is in Israel in peril since a new government took office in that country at the end of December. The claim that the political right is seeking to end democracy was the centerpiece of the Democrats' midterm election campaign last November. But it didn't work quite as well in Israel when it was employed by the coalition of opposition parties that sought to employ it to prevent Benjamin Netanyahu from winning his record sixth term as Israel's prime minister in a vote that took place a week earlier. The Republicans did wind up winning a narrow majority that enabled them to retake the House of Representatives while winning more than 3 million votes than the Democrats nationwide in House races. But they lost ground in the Senate, leaving the country with a divided government, meaning that the smearing of Republicans as a party of would-be authoritarian deplorables did help the Democrats stave off what many had thought would be a red wave election. But the talk about saving democracy didn't work quite as well in Israel, as Netanyahu's coalition, consisting of his Likud and a group of religious parties, won a clear majority. Armed with that majority, Netanyahu's coalition has set about trying to govern the country, and in many ways has hit the ground running, implementing some changes in policies that their voters hope will deliver more security against a new wave of Palestinian terror attacks, an issue that did help decide the election. But they're also seeking to implement one key point in their platform: judicial reform. New Justice Minister Yariv Levin and his colleagues have begun the process of pushing through legislation that will seek to check the power of Israel's Supreme Court, which has, in the last 3 decades since the time of Chief Justice Aaron Barak, arrogated to itself virtually unlimited power to override the Knesset and to interfere in every aspect of governmental action. But what has made the court's activist role so controversial and indeed outrageous is that its power is not based in any set of laws or constitution to which Israel's voters have consented, but was simply imposed from the top down and allows the judges to act on the basis of whatever they think is or isn't reasonable, rather than playing an impartial umpire role of judging cases according to the laws written by the legislature. What's worse, the court has been basically allowed to pick its own successors, so its ideological composition and willingness to continue this power grab can't change. Netanyahu and Levin want to change this to prevent the court from overriding the Knesset with impunity, as well as to make the post of Attorney General more accountable to the voters and their elected officials. Also part of the package is a bid to end the practice by which legal advisors can veto virtually anything that the government ministers wish to do without any ability to appeal or override often arbitrary judgments. That the legislative branch has waited until now in order to try and push back against this speaks volumes about how entrenched the power of the legal bureaucracy is in Israel. But the anger and hysteria that the reform scheme has generated among the political opposition demonstrates how much the existing establishment fears the loss of their power. And much like the tactics Democrats employed after Donald Trump won the 2016 presidential election in the United States, Netanyahu's foes are forming a resistance rather than an opposition, loyal or otherwise. And they've been able to mobilize tens of thousands of people to turn out for protests aimed at stopping what they claim is Netanyahu's push to end democracy and turn Israel into an authoritarian state where secular liberals would be unwelcome. And the people organizing and cheerleading for these protests are using the liberal media in the United States to second their claims about the end of democracy, seemingly heedless of the fact that what they're trying to do is actually defend an anti-democratic judiciary, and that their claims about Israeli authoritarianism are playing right into the hands of the intersectional and anti-Zionist left, which opposes the existence of any Jewish state, with or without an unaccountable liberal Supreme Court. To get to the bottom of this issue and to explore just exactly how the Israeli judicial system currently works and whether reform is necessary or possible, we're pleased to have with us one of the keenest commentators on legal issues today. Jerome Marcus is a lawyer in private practice, a fellow at the Kohelet Policy Forum in Jerusalem, and president of the Deborah Project, a public interest law firm representing victims of anti-Semitism and anti-Zionism. He's also served as a federal prosecutor and as special advisor to the legal advisor of the U.S. Department of State. Jerome Marcus, welcome to Top Story.
Thank you, Jonathan.
Well,
very glad to be here.
Well, thank you for joining us. So we're really thrilled to have you. I want to start by asking about how the controversy about the Israeli Supreme Court started. So first, has the court always been as powerful as it is now since the beginning of the state? And what and how did change to give it the kind of power, really unaccountable power, that the new Israeli government wants to pull back from it?
The answer to that question really takes you back over 40 years. And I think that there's an important sort of demographic and political dimension to it that is outside the law itself, but that I think is actually driving what we're witnessing today. So if you go back to the history of Israel's Supreme Court, Israel, of course, is a parliamentary system. It's a unicameral legislature. And it had no written constitution. The intention was, to create one. And in the interstices between the wars and everything else that was going on in Israel, they just kind of never got around to it. So there is no written constitution, but there is what is essentially the tripartite government that all Western countries, the United States, obviously Great Britain, which is where this all tends to come from, and most Western democracies have. There's a judiciary, there's an executive, and there's a legislature. So in the beginning, from 1948 really through the 1970s, the Israeli Supreme Court, in the absence of a written constitution, did not engage in what we here call judicial review. That is to say, it did not sit in judgment on the legitimacy of statutes, of acts of the legislature. My own sense is that the cause of what we're observing was a political revolution that preceded the judicial revolution. The political revolution was that in 1977, for the first time in the country's history, somebody was running the country other than the left. Menachem Begin, won, and the Likud won power. And lo and behold, beginning in the 1980s, the Supreme Court began to flex its muscles, really under the leadership of one man, Aharon Barak, who was a justice and then the Chief Justice of the Israeli Supreme Court. And to a degree that you would think I was being hyperbolic when I said it this way, but it just seems to be generally acknowledged, and it happens to be in fact the case, that he just declared a judicial revolution. He just decided that the Israeli Supreme Court needed to be doing things that it hadn't done before. And so over the course of roughly 15 years, beginning in the early 1980s and extending into the 2000s, Barak led the court to essentially seize power that it had not had before, and that no one else had granted to it. And he did that in a variety of ways. He abolished two principles that have historically constrained courts, Western courts, around the world: standing and justiciability. So standing is the idea that only certain people can come into court and ask the court to do something. And they are, in American law, they're required to be people who have an interest in the outcome of the case. You can't just go to a court and say, you know, I think this is an interesting question, you should answer. And the reason for that is the courts, most courts, don't give what are called advisory opinions. That is to say, they don't just decide one day that they should render an opinion and tell you what they think about something. Courts are there to resolve cases the way American courts speak about it. They're there to decide cases and controversies, which is the language of Article 3 of the Constitution, which is the article of the Constitution that creates the U.S. federal judiciary. And so there's an idea that you can only go into court if you have a case. That is to say, if you have an interest in the resolution of an active dispute. And that's a limitation on the power of courts, because it means that they can't answer any question just because they feel like it, or because someone feels like they'd like to hear what the court has to say. There has to be a live dispute. And the second idea is the idea of what's called justiciability, which is the idea that in order for a court to speak, there has to be a law that can answer the question that the court is being asked to address. And so there are some instances where courts are asked to decide cases where there isn't any law. And the classic example, and it's one I gave in a piece that the JNS published a week or so ago, is that the United States Constitution tells us how to make treaties, but it doesn't tell us how to unmake treaties. It doesn't say what process can be undergone to make a treaty no longer be in effect. And so in the early 1980s, the question arose whether a treaty that we had made governing our relations with China could be undone. And the question was put to the Supreme Court: what is the procedure for undoing a treaty? And the Supreme Court said, there is no law governing that question. And so we, as judges applying the law, don't have an answer. It's a political question. It's a question that the other two branches of government, the political branches of government, are going to have to work out for themselves. The political branches being the president, which is the executive branch, and the legislature, in this case, the Senate, but maybe the House too, which has funding power over foreign affairs. And the Supreme Court said, look, we don't have a dog in this fight, and we don't have the ability, we don't have any standards by which to resolve this dispute. So we're not going to address it. And the justiciability argument had been an argument in Israeli law for decades. And in fact, for example, excuse me, in 1970, somebody went to court and said, you know, it's not fair that yeshiva students have an exemption from the army. You should declare that illegal. And the Supreme Court said, we don't have a standard by which to judge that. And they turned the petition away. And in 1981, the same question was raised. And the Supreme Court said the same thing. But in 1986, the question was raised again. And this time, Aharon Barak was in charge. And so he decided that, yes, in fact, we do have the authority to resolve that. And one of the ideas that animates his decision is that there is no such thing as a space in society that is ungoverned by law. And the concept seems to be that if there were no law, there would be no standards, and the world would be in chaos. And I say this, you will think again that I'm being hyperbolic when I say it, but the claim really does seem to be that there is no area with respect to which I, Aharon Barak, and the others like me cannot improve the world by telling you what we think. And again, you'd think I was being hyperbolic, that I was being unfair as a characterization of his idea. But by abolishing the idea of justiciability, he also inserted another idea, which is that the standard by which the Supreme Court can judge cases, if there is no statute, is the standard of reasonableness. That is to say, what the judges think is reasonable, which is, it seems to me, just an astounding arrogation of power by any individual person. And so when the people in Israel now who are opposing these reforms suggest that democracy is being threatened, the right answer is no. Democracy was threatened 40 years ago when this was invented, and it wasn't threatened, it was actually diminished. The Supreme Court in Israel has asserted the power and has exercised the power to govern and to decide what's reasonable. And that is the assault on democracy. And what the governing coalition is now attempting to do is to reverse that. It is a counter-revolution, and it is a democratic revolution, which in moments of quiet, the people who oppose this essentially acknowledge. What they're really saying is, we don't want the majority to be in charge of the things that these reforms will put them in charge of, because that's dangerous. And so you have to ask yourself, well, if the majority isn't in charge, who is in charge? And that brings me to the demographic point that I referenced a little while ago, which is that this is what's really going on here, is that this is a battle about who's in charge. And the Chilonim, the secular Ashkenazi minority, has run the country ran the country for the first 30 years of its existence. And they have, to a certain extent, been displaced by by people who don't think the same way they do. And they're really people who think, or at least who are educated, the same way you and I were. These are all university-educated people. They're very much Western-oriented people. And they're being replaced by Mizrahim, they're being replaced by Haredim, they're being replaced by religious Zionists. And the Chilonim don't like it. And so the reforms that we're looking at now are reforms that essentially take power away from the Chiloni establishment, both on the court and with respect to the laws governing the attorney advisors, unquote, which are the legal counsels essentially for the various ministries. It's a separate statute, but it's really part of the same problem, which is that under Israeli law, currently, the attorney advisors that sit next to the cabinet ministers don't simply advise. They issue opinions on what the law dictates with respect to the activities of the ministry, but those opinions are binding. And these are career people. They're not placed there by the ministers for the departments. And so they get to decide what the ministers do. And they get to rule out of bounds whatever they think is inappropriate. And so what you have here is a system between the lawyers governing the departments and the court governing the legislature is a small minority of the country governing everybody else. And the reforms that are being proposed now are efforts to undo that, not quite completely undo it, because it doesn't completely undo it. The statutes that are being proposed would not completely undo these things, but they would diminish the power of this minority. And that is why you see such outrage from the people who oppose these statutes. They're the people who are wielding this power, and they just don't want it taken away from them.
Jerome, I guess the question is not just how did Barak pull this off, which is obviously, as you said, he just, decided it. But why didn't anyone try to push back against this until now? Because it really was a revolution in law, a revolution in governance, but it kind of just went along all this time. How is it that, the Israeli the Israeli right, or the conservative religious really majority in Israel has only just now gotten around to addressing this?
Well, I think there's a couple of things at work. first of all, there's no doubt Israel is not the United States. It's not any other country. And there is, I think, a part of the zeitgeist, and I say this just, from reading the papers and knowing the people that I know and having thought about what goes on in Israel for a long time. There is a distaste for politics and a certain sort of, I want to say almost German respect for experts. And I think
And
there is
authority.
a tremendous, well, not just authority, but expertise. There is a yearning, and this was something that was, it's part of the appetite for the administrative state in the United States. It's a desire to find people who are objective and knowledgeable and trustworthy, and to say to them, you decide, you wield power. And, I think that hope is fundamentally at odds with the founders' view of separation of powers, as is expressed in the Federalist Papers and lots of other places, where they essentially said, there's really nobody that we can trust to wield power without somebody else putting a brake on them. And so the solution to the problem of where do you place political power is you place it in a lot of different places, in a lot of different hands, and then you require everybody to sort of duke it out together, and whatever comes out of that sausage-making process will be the best possible result, rather than simply saying we're going to place power in the hands of experts and we'll trust them. But even so, even there was a sense that the courts were, in some sense, the aristocratic branch of government. Courts are made up of judges. Judges are made up of lawyers. Lawyers are people who've gone to college. There's, I don't want to say there are no poor lawyers. There are plenty of poor lawyers, but there aren't a lot of poor lawyers who get appointed to positions of substantial responsibility in the federal government. Because, as I think Mencken once said, a judge is a lawyer who knows a senator. So if you know a senator, you're not a trash man. You're somebody who is a person of substantial means. And who are those people? Well, they're the upper middle class, and they have a particular view of the world. And I think in Israel, there is a yearning for that degree of expertise to run the country in a way that's not political, that's not subject to, the ethics of the bazaar, of a rug merchant, and to be crude, and a desire to place political power in the hands of people who can't be corrupted. The funny thing is, or not so funny thing, is that the people who wielded this power have been delighted to understand themselves to be this. And I want to, there's one concept that I find, one formulation of the concept of where power should be placed that Barak himself used, which again, if you weren't sure, you would think that somebody was making this up and putting hyperbolic words into his mouth. But when he was trying to figure out how to interpret the clauses that gave him the power that he claims he has or had to determine what the ruling principles of Israeli law were, he says the basic law governing human rights in Israel was a statute called the Statute of Human Dignity and Liberty. And it makes Israel a Jewish state, a Jewish and a democratic state. And so Barak spoke once, or many times, about how you mediate between the Jewish part and the democratic part. And what he says is that when the attempt to make the Jewish part and the democratic part work together, when that attempt fails, and the values of the state of Israel as a Jewish state cannot be reconciled with its values as a democratic state, there's no escape from the need to decide. And then he says this decision must be made, in my opinion, according to the views of the enlightened community in Israel. Well, to be blunt, who the hell is that? Who is the enlightened community in Israel? Well, you'll be shocked to learn the enlightened community in Israel is the people who think like Aharon Barak. Those are the enlightened people. And to answer the question that you asked a moment ago, why did it take so long? I think the answer is that in part, the unenlightened community in Israel has only recently attained enough power to be able to actually stand up on its hind legs and say, we're going to put a stop to this. And I think in part it's because there was a reluctance to push back until it was absolutely necessary. But one of the features of power, as we all know, is that the more power you have, the more aggressively you wield it. And I think that the Supreme Court, over the last few decades, has pushed further and further towards the exercise of just sort of whatever we want, nullifying political appointments and nullifying laws, even, and this is a fairly recent development, even asserting the power to nullify a basic law, which is really astounding. So the theory of judicial review...
Explain basic laws in Israel.
I will.
To
in Israel,
audience.
There's just a Knesset. As I said earlier, there's no written constitution. So there are certain statutes that are organic of particular departments and particular areas of law. So in the United States, for example, there's the Judiciary Act, which creates the federal courts. It's just a statute. It could be overturned tomorrow by another statute. It's an act of law like any other law. But it's a really important law. And in Israel, there are certain statutes that create ministerial departments and that establish the law governing certain areas of law. And those are called basic laws. They have been passed in the same way that all other laws are passed, except that the Knesset declares that it's enacting a basic law. So in the 1980s and then into the 1990s, Barak decided, when the basic law of human dignity and liberty was enacted, Barak decided, we'll use this as the Constitution. And there had been some intention that these basic laws would be enacted over the course of time and that they would ultimately be sort of rolled up together and create the Constitution. That never happened, but Barak decided he would take this law and make it into a tool that he could use in the exercise of the power to review the legitimacy of other laws, that it was somehow above other laws. It wasn't, but Barak declared it to be. So most recently, when Netanyahu was in power last, when Likud was in power and the right was in power, they enacted the nation-state law, which declared, in language that quotes what I read earlier, the state of Israel is the nation-state of the Jewish people. And in the wake of that, the Supreme Court has now asserted that it has the power to overturn a basic law. They haven't exercised the power, but they've asserted that they have the power to overturn a basic law. So just think about that for a minute. What they're essentially saying is that they have the power to declare the Constitution unconstitutional. They previously said that the basic law was the Constitution, and that they would use that as the mechanism to review and assess the legitimacy of other statutes. But now they're saying that they have the power to assess the legitimacy of the fundamental statute, of the basic law itself, which is, again, an astounding assertion of power. And I think that, too, is one of the things that answers the question you asked earlier, why did it take so long? I think that was one of the moments where the people on the right said, all right, wait a minute, that's just a bridge too far.
Mm-hmm. Well, as we get into some of the details here, and you've discussed the basis on which the court gave itself that kind of power, but how does this compare to the judicial system here in the United States, where you have a written constitution, and perhaps even more importantly in Britain, where, like Israel, there also isn't a written constitution? And that is something that some of the Supreme Court's defenders and the opposition to judicial reform cite. Is Britain really, is it different? How does that play into this?
So it's different and it's the same, but it's really more different than it is the same. The short answer is that in England, this battle was fought 400 years ago, when the lawmaking power was asserted by one person wearing a crown, and when disagreeing with the lawmaking power was a little more dangerous than it is now. But during the 17th century, the power was briefly asserted by it was the House of Lords, but by the courts in England to countermand the directives. Right. Yes, the Lord Chancellor. So, right. They are a member. Well, now, right now, things have been sort of, I don't want to say rationalized, but made to look more like the United States. They have a Supreme Court. But in any event, the judiciary asserted the power to strike down the act of the king. And you'll be shocked to learn that the king didn't like that very much. And even Parliament didn't like it very much. And so, with the exception of certain treaties, like the treaty between England and Scotland, even though the UK does not have a written constitution, the courts in England have learned their place. And they simply don't do this. They haven't done it for 400 years. And the concept of parliamentary supremacy is very, very firmly established. And the courts don't exercise this kind of power. I mean, the idea that the courts could exercise the power to strike down an act of the legislature because it was unreasonable is just, it's beyond the pale in the UK. In the United States, it's illegal. I mean, it is not a legitimate exercise of the power of judicial review. And even the most aggressive assertions of that power on the right during the Lochner era in the late 19th, early 20th century, and under in the Supreme Court under the Warren Court, which I think was sort of the high watermark of judicial power in the last century. Nobody claimed the right to simply strike down a law, whether a state law or a federal law, because 5 justices on the Supreme Court thought it was a bad idea. They always appealed to some legal doctrine, whether it was substantive due process or something else. There was an effort. I mean, even Roe v. Wade makes an effort, not a very good one, but there's an effort to make the Constitution answer the question. They did not have the chutzpah to simply say, this is an unreasonable statute, and so we're going to strike it down. And so when you look at other courts, at least the courts of civilized countries, there are no courts that I'm aware of that do what the Israeli Supreme Court has claimed the right to do and has done.
Yeah, but that's really amazing. I mean, we speak of Israel being the only democracy in the Middle East, and it is, but it certainly is the only one with a Supreme Court that arrogates to itself that kind of power in the Middle East or anywhere.
As far as I know, it is the only court that exercises that kind of power. I mean, I think, in some ways it's sort of like the way the army used to run things in Turkey back in the good old days, where they would tolerate a certain amount of, fooling around by the government. But when they thought things had gotten out of hand, they would just have a coup. And in Israel, they don't have coups in the same way. But what the Supreme Court has done and what they're contemplating doing right now with Aryeh Deri is simply deciding, well, we just don't think he's appropriate to have as a minister. So
he's the head of the Shas. Just to explain, he's the head of the Shas party, the Mizrahi ultra-Orthodox party. He has a criminal record. He's been convicted of past charges of corruption and other things, multiple times, and which he claims are political charges. But the court is now contemplating saying it's just not kosher for somebody with a criminal record to be a minister, even though his party, won seats. It's part of the governing coalition.
Right. So, there are things that could have been done that would make this actually a legal question. So, for example, in the United States, if somebody is impeached and convicted by the Senate, the Constitution provides that he's disqualified from federal office. And in Israel, there is a law that says that if you are convicted and you admit to a concept of kalon, which is essentially disgrace, it's an admission of corruption, you are ineligible as a legal matter. Deri did not, in his last conviction or any of them, accept that formally. He did say during his guilty plea that he really wanted to spend more time with his family and was leaving politics. It was not, as far as I understand from reading the Israeli papers, an explicit quid pro quo. We are accepting your guilty plea on the condition that you abandon politics. He said he was leaving politics. And my understanding from reading, excuse me, accounts of the oral argument in the current challenge to his tenure, that was part of the question. So, like, is this the same? It seems to me if that were the question, it would be a legal question. And it would be an appropriate question for the court to answer. But what the court is actually trying to decide instead is not that. What the court is trying to decide is whether it has one of the following two bases for excluding dairy. One is it's unreasonable to have a slimeball who's been convicted 3 times of corruption from serving as a government minister. That's the principle of reasonableness that I alluded to earlier. And when it comes to selecting government ministers in essential parts of a governing coalition, again, it's truly astounding that any number of judges would assert the power to decide whether, in their view, it's reasonable when I think 394,000 people voted for Shas, and they apparently did think it was reasonable. So what you're looking at here is simply the reversal of 394,000 votes on this side, and since it was a panel of 11, 6 votes on this side, but those 6 votes, as Abraham Lincoln said after he had the cabinet express their opinion, the ayes have it, because he voted the way he voted and he was president and they weren't. So with respect to the concept of reasonableness, the idea here is that 6 justices on the Supreme Court are going to decide a question that was previously put to the Israeli electorate. The other basis that they have for disposing of him is that there was a basic law which determined that somebody who'd been convicted of a crime which was punishable by a term of imprisonment could not serve. And when this current Knesset was formed, one of the first things they did was change that basic law to say that he would only be ineligible to serve if, in fact, he went to jail, which Derry did not do. So obviously the statute was enacted to provide exactly for this, but it's a basic law. And so the only option that's available to the court in order to disqualify Derry, other than deciding that his appointment is unreasonable, is to strike down the basic law, which, again, is the assertion that the Constitution is unconstitutional. I mean, it's completely
incoherent. Yeah, that's, the court here can say, well, something is constitutional or not. They can't say that the Constitution isn't constitutional.
No, they certainly can't. I mean, the one thing that they could do is they could say that, for example, a provision that someone said had been a proposed amendment to the Constitution had not been enacted in accordance with the procedures set forth in, I think it's Article 6 of the Constitution, which governs how the Constitution be amended. But they certainly could not say that the provision was substantively invalid because we, the justices, think it's a bad idea. And the standards that are being bandied about, I can only say, as the basis for striking down parts of the Constitution as unconstitutional are that it's somehow inconsistent with the rest of the zeitgeist of the Constitution. It's not consistent with the spirit of the rest of the document, which, again, is just, the assertion of the power that we think this is really bad and we don't give a damn what anybody else thinks, including the electorate.
Yeah. So you've shown us just how extensive the court's activism has been, and that there doesn't seem to be anything that in Israel that the court doesn't believe it can't overturn.
Oh, on the contrary, they are explicit. They are explicit. There is nothing. There is no area of society, according to Barak, that is ungoverned by law or ungoverned by the principle of reasonableness, and therefore there is nothing, including, for example, the exercise of power on the battlefield. So one of the things that the Supreme Court of the United States has never purported to govern is what happens on the battlefield. The Supreme Court has not ever said, we're going to tell the generals how to fight wars. But the Supreme Court in Israel has, to the point where the law takes an active role in the conduct of hostilities on the battlefield while the weapons are hot and they're being used. I happen to know, because I've had some involvement with it, not engagement with it, but some study of it, that there are direct communications between fighters, pilots, and legal authorities while they are engaged, so that the question can be answered, may I press the button now? And that question is answered by groups of people, including lawyers, philosophers, ethicists, who were sitting there on the other end of the telephone answering the question whether a particular weapon can be launched at a particular time at a particular objective, because the law is understood to be governing in that situation, which is something that would not happen in the United States.
Yeah. So basically, what you're telling is that there are no current limits on the power of the court.
That is what I'm telling you.
So that's just
there are no limits
now,
substantively or in terms of the nature of the kinds of questions that can come before the court.
Right. Now, those who oppose this reform package are claiming that without the court having this kind of power to override the Knesset at will, narrow parliamentary majorities can assume dictatorial powers and at will take away the rights of Israel's citizens and become an illiberal state, or as some of the people at the demonstrations this past weekend were saying, to become a tyranny of the majority, that would prevail. Is that true? And what does the law have to say about that?
Well, of course, what does the current law have to say about it, or what does the law that's being proposed have to say about it? So the short answer is, in my own heart of hearts, I do believe that it's important for there to be some restriction on the scope of majority power. In a country with no written constitution, the source of that restriction can be hard to locate. And if you look at what goes on in England, what the ballast that keeps that country from being overtaken by the tyranny of a majority is 1,000 years of legal tradition. Israel doesn't have that. I mean, we either have 75 years of legal tradition or we have 2,500 years of legal tradition, but
depending on what kind of law you're talking about, yes.
Exactly. And the number of people who are prepared to rely on the 2,500-year version is a lot smaller than the number of people who are prepared to rely on the 75-year version. So there is a problem. And I think that it would be a mistake to simply say, oh, we can just let the 64 votes that currently are held by the Likud and its coalition partners decide everything. But I think that there is another answer, and it's the American founders' answer, and the answer is called politics. And I think that what the people in Rabin Square and everywhere else who are protesting this law fear is that politics can't work, that the process of factions and groups of different political groups sort of duking it out together cannot work to protect minority rights. But even the statutes that's being proposed do not wipe out minority rights. They allow, for example, the Supreme Court to overturn a basic law. That is to say, they do allow the Supreme Court to say that the Constitution is unconstitutional. It requires a unanimous vote, but it does permit it. So I think that, and I also think, and this is again, Netanyahu in the last few days has sort of told everybody to calm down, and there's not a need for the degree of hysteria that's being expressed here. And if you read the Israeli papers in the last few days, there are efforts to reach some sort of compromises. The precise content of those compromises, I don't think has been detailed in the public domain as far as I can see. But there are negotiations being conducted now between the Supreme Court, which I find actually sort of astounding, and the coalition, and perhaps Gantz's party, which is sort of the most willing to engage with the coalition, to try to figure out if there's some way to have some of these reforms and not others. What I find most unfortunate is that I think Israel frequently tends to import things from the United States with a few years delay. And what we're witnessing in Israel now is really Trump derangement syndrome being imported and applied to Netanyahu. So You have, Gideon Sa'ar Yehuda Weinstein was a former Attorney General of Israel, and he announced that the judicial reforms being proposed here are a pogrom. Barak called it the strangulation of democracy. The people on the left are calling this literally the end of the world. It is the end of the world. It's the end of democracy. It's the advent of fascism. It's Nazism. It's the standard argument ad Hitlerium that one sees from people who I think don't have a lot of logic to their position, but who want to get a lot of people upset. And I think it's extremely unfortunate. It makes rational conversation impossible. I do think that there's an interesting problem of how you defend minority rights. Part of the problem is that the people who claim that they want the minority rights defended are only interested in defending some minority rights. So, for example, if the Haredim want to go to the beach and say, well, we'd like to have some time when we could go to the beach and we need gender-separated beaches. There are not a lot of people who, on the left, who want to defend that minority. And so the question of defending minority rights also resolves to which minorities. If it's the 40% of the country that lives in Tel Aviv and thinks like Tel Avivians, that minority they're very interested in protecting. Other minorities, maybe not so much. And I think that's part of the problem, that their consciousness about what constitutes a minority and what minority rights are really in need of and entitled to defense probably needs a little bit of expansion.
Yeah, well, I think, we've discussed, this aspect of the judicial reform proposals, about the changes in the role of the Attorney General, the ministerial legal advisors, and why they're important. But I guess with the Supreme Court, how is it that the court gets to essentially also pick its successors? I mean, that's an important part of this.
Yes.
Because for a long time, they just basically did. Now they have a veto power over, new nominees. Is there any other example in a democracy where the judiciary is sort of like it's sort of like a tribe? It gets to, sort of pick its successors and, extend its legacy, indefinitely, so that, change is basically impossible.
So the answer is that there are, in England, the process of picking judges is not so different. Well, that's not true. It is different, but it's doesn't look like it looks like in the United States. So in the United States, it's a political process, as we well know. And although in your and my memory, the beginning of the political wars in the court is Robert Bork's confirmation, but that was not the first. When the battle over the Supreme Court's appointments in the 1950s, when segregation was on the court's docket, there were battles, and they were carried out politically with expressed political goals. Everybody understood what was at stake. But in England, the process of picking judges is delegated to a committee, which includes judges and it includes experts, and they make selections, which are then given to the prime minister, who is essentially bound by them, and he gives them to the king or the monarch, who is bound by them, and they get appointed. But the difference is that they're not extending the degree of power that Israel's court is, because they don't wield that degree of power. They really are only following the law. And the principle of parliamentary supremacy is bedrock in England. So right. The idea that the courts could be, that by appointing judges, you would be perpetuating this kind of power is absent. But I do think that the way the system has been constructed in Israel is a function of something that I mentioned earlier, which is the distaste for politics and the yearning to find somebody who can wield power in a way that is antiseptic, that is disinterested, that is free of political considerations. And I think the committee that has exercised that power over the last 75 years, which is a 9-member committee that includes 3 justices of the Supreme Court, and where 7 members of the committee are required to appoint a Supreme Court justice. So if the three justices work together as a block, they have a veto. But even the proposal that's being made now by the coalition is not to have the power handed over to the legislature. It's to expand that committee from 9 members to 11 members, leave 3 justices on, and to take away power from one group, which is lawyers in private practice. Under the current arrangement, there are 9 members of the committee, 3 justices, and 2 members of the bar, which are just the heads of the Bar Association or their designees. And so what you have, again, is this very aristocratic group of university-educated, upper-middle-class people who are appointing, by the way, the people in front of whom they're going to argue, which is, it seems to me, a tremendously problematic dimension. So those people, under the current proposal, are to be removed and replaced by members of the public. Now, there are members of the public that are going to be appointed by the ruling coalition. So the expectation is that they're going to agree with the ruling coalition. But the ruling coalition is not going to be the Likud and its friends forever. The left is going to be back someday. And I don't think, as an American and an American lawyer, I've sort of learned to live with the idea that there is no refuge from politics. Periodically in the United States, there are efforts to, quote, depoliticize, unquote, the Justice Department, and to have criminal prosecution be separated from politics. But that's not the way our Constitution does things. It is subject to politics. The Attorney General is a presidential appointee subject to Senate confirmation, just like everybody else. There is no place to go other than ultimately the political process, which ultimately means the people, because that's who gets to decide. And so I think that the flight from politics in Israel's system, both with respect to the substantive power of the court, with respect to the power of lawyers over government ministers, and with respect to the power to choose members of the court, is ultimately, I think, hopeless, because the power gets wielded by somebody in the interest of the people who are wielding the power. That's just what happens. And in the past, that's been wielded by the Ashkenazi liberal minority. And finally, those people are out of power, and the people who are not them have the power to do something about it. And that's what we're seeing with respect to all of these proposals, with respect to the appointment power for the court, with respect to the substantive powers of the court, and with respect to the powers of the lawyers inside government ministries.
Jerome, I think you've outlined for us that this is more than about legal theory, more than about just, ideas about law, and that this is also about a sort of political conflict between Ashkenazi elites and the right-wing Mizrahi and religious deplorables. But, I think the hysteria that you've alluded to and that, we've reported about at JNS is rooted in something, that was, as you rightly alluded to, in, former Supreme Court Chief Justice Aaron Barak's own writings and thinking, in that, his goal was to sort of apply international human rights law to Israel, because he felt that in the absence of imposing, what is, as you quoted before, what enlightened opinion thought, Israel would descend into sort of Middle East barbarism. And I think that was partly a sort of what he thought about, as I say, these Mizrahi and religious right-wing deplorables. But how is that to be, adjudicated? Where do we go from there? When this is such a basic idea that if, the good people aren't running things, then Israel isn't a democracy. So as much as it sounds like hyperbole and just basically copying sort of Democratic Party tactics from the last, election about, the foes being, opponents of democracy and would be authoritarians. But I think it's rooted in a genuine belief that if sort of the, sort of secular liberal elites are not running Israel, Israel will be, just another version of Syria and Egypt, but just with Jewish, or even Iran, just with, Jewish mullahs instead of, Islamist ones.
I don't think this is I don't think this is an Israeli idea. I think this is a leftist idea, and I see it in the United States, and I don't know if I see it in other countries, but I don't know how knowledgeable I am about other countries. But I certainly see it here, and I don't think, although I think it got much worse under Trump. I think that it was the same under every Republican president that I can recall going back to Reagan. Republicans are all Nazis as far as the Democrats are concerned. Republicans were conducting a war on women 30 years ago, a war on women. And I don't know whether they really believe this stuff or not, but I think that the willingness to taint your adversaries as fascists is not unique to Israel, and it's not new. Now, I don't know whether the people on the right are guilty of the same hyperbole. Maybe. I'm a man of the right, and so I tend to view a lot of criticism of people on the left as accurate. But I have plenty of friends on the left, and I don't think they're fascists. And I can recall a time when I thought the way they think or thought things that are very close to what they think. So I'm not prepared to say whether it's just sort of politics. I mean, if you go back to the way politics was conducted in the United States at the turn of the 19th century, nothing that the Jeffersonians had to say about John Adams was any less horrible, or the other way around, was any less horrible than what's being said in Israel today. So maybe it's just that politics ain't beanbag, and that's just the way it is. But I don't think it's just Aharon Barak. I think the appeal to international law is not because he actually believes in international law. He believes in his own opinions and is prepared to enforce them. I do think that's a substantive distinction between the left and the right. When I think the right, when it's in power in the court, at least in my lifetime, has not enforced its own worldview. I don't think Antonin Scalia wanted to use his power as a justice to make everybody think or be governed by the substantive decisions that he would make as a voter. But I do think that's what Aharon Barak wants to do, or wanted to do. And but I don't think it's a uniquely Israeli problem. I think it's a problem, at least of the left, and maybe of politics generally. I can't tell.
Jerome, how should Americans regard this issue from afar? And how much damage do you feel the rhetoric about democracy and about the end of Israeli democracy is doing to Israel's standing in the world at a time when we know anti-Semites are seeking to make the same point about it with smears about Israel being an undemocratic apartheid state? Are they kind of unwittingly playing into this, or is this part of, at some point, does the secular left really believe that Israel becomes illegitimate if they're not running things?
Oh, I don't think there's any doubt that the secular left believes that Israel becomes illegitimate if they're not running things. I can't tell what the long-term damage is. I certainly observe many people, including at least one person that I'm very fond of, because she's my daughter, be genuinely appalled and frightened by people inside the government, or some of them, even though, at least in my daughter's case, she, I have no doubt, deeply loves the country. But I think that there are plenty of other people who don't deeply love the country and who are delighted to use this as a stick to beat Israel with, because it's handy. They would be using another stick if this stick weren't available. I do observe many people. Hillel Halkin had an impassioned piece in the Jewish Review of Books very recently that was, I mean, I don't know how you say harif in English, but it was very, very bitter, angry, sad piece about the danger being presented by the coalition in general and these proposals in particular.
I've seen,
no doubt.
I think, Yossi Klein Halevi's piece in The Atlantic, and basically everything that David Horowitz has been writing in the Times of Israel recently is along the same lines.
Right, but at least in David Horowitz's case, he was saying the same thing about Netanyahu, 10 years ago and 5 years ago and 5 minutes ago, and there I think it's just it's about Bibi to some extent, but I don't know how much damage it will do. I think in part it's going to turn on how long this takes, what ultimately is the prospect. I mean, one thing that frightens me is what happens if this statute is enacted and the Supreme Court strikes it down? Then where do we go?
Yeah, what happens then? I mean, it sort of becomes a John Marshall, Andrew Jackson kind of confrontation, to allude to something from American history, but I don't know how that works in Israel.
Well, I mean, I hope it doesn't get to the question of, well, how many divisions does he have?
Yeah.
To quote,
well, Jackson famously said of John Marshall has made his decision. Now let us see him enforce it. Right.
Yes. Right. But I don't know if it would go that way in Israel. And so I think that would be really scary. And I think, frankly, that one of the reasons why you're seeing negotiations is that even Bibi doesn't want to get there. And I think that this Supreme Court would, at least conceivably, do that. And then just sort of stand there with their arms folded and say, well, what the hell are you going to do about it?
Right. Well, and that's kind of an anti-democratic, that sounds like an anti-democratic coup to me, but.
Yes, but remember that, to go back to something you said earlier, to a certain extent, democracy is not just 50% plus one wins. There's an idea, which I think the right should be delighted to acknowledge, that there's such a thing as minority rights that are a part of a democratic society. And the right doesn't need to be afraid of that. On the contrary. The question is how to do that without having the minority rights that are being enforced be only the minority rights of a bunch of upper middle class white people who are enforcing their own policy preferences. That's not the protection of a minority rights. And I think that when it's the latter in the guise of the former, it's a problem. And I think that's really what we're seeing. To answer your question about how it's going to hurt Israel over the long term, I think there are so many other factors at work. If Bibi can make a peace treaty with Saudi Arabia, it's not going to matter a whole lot.
Well, okay. Well, that's a hope. That's a hopeful note that we can end on. Jerome, I want to thank you so much for coming on today and giving us your insights on these issues. It was really valuable. We also want to thank our audience. Please remember to tune in every day for Top Story Daily Edition. And whether you're listening to us on Spotify or any of the other podcast platforms, Apple, Google, or whatever, or watching us live on Facebook or Twitter, or on the JNS YouTube channel, or on JBS TV, please like and or subscribe to Top Story, click on the bell for notifications, and give us good reviews. Please write to us at editor@jns.org and let us know where you listen or watch the show and what you think about it. And we'll remember this was episode 80. We're looking forward to episode 81 next week. And remember, keep reading and thinking for yourself. And we'll see you again next week.